Hello everyone and welcome to the Lauterpacht Centre for International Law and the Hirsch Lauterpacht Memorial Lectures 2021. Those of you who have been attending the previous two lectures will know that we are partway through something really rather special. For those of you who have not been able to join us previously, you are in for a treat. I know that everyone has been waiting patiently for this final lecture on dignity and indignity in the South African toilet wars. But if you will allow me one personal remark before we begin, it is a particular pleasure to chair this lecture because Professor Marks was my teacher of international law and international human rights law some years ago. And it was she who showed me that it was possible to have a career in international law, for which I am enormously grateful. Before I turn over the floor, let me remind you that tomorrow we will have a discussion session starting at 1 p.m. UK time. So please hang on to any questions or reflections until then. Susan, thank you, and the floor is yours.
Thank you, Sandy, for that lovely introduction and the lovely memory of our time together at Emmanuel College, Cambridge. I'm going now to try and share my screen once more. So hopefully you can see the first slide there. So I spoke at the end of the last lecture about the need for counter-knowledge to uproot the ideology of race, and about how a counter-history of dignity could be part of that. In the larger project to which these lectures relate, my attempt at a counter-history of dignity will unfold in several parts. The first part will look at certain events in mid-19th century Australia. The second part will consider developments of the early 20th century in India. You'll have to read my eventual book to find out what I have to say about those times and places. Tonight, I present a third part, which is concerned with phenomena of our own time somewhere else. What does dignity mean in the 21st century? For many people today, an everyday experience that raises the issue of dignity literally every day is going to the toilet. As the slogan of one campaign puts it, sanitation is dignity. And here you see an image from a photographic exhibition that was part of a campaign mounted by a European NGO. There's another couple of images from that same exhibition. Sanitation is dignity. Of course, sanitation is also health, safety, and much else besides. Yet even the most cursory glance at relevant materials will reveal that dignity looms large in the matter of toilet access. There exist struggles around dignity and sanitation in all countries of the world. In this lecture, we look at a country where those struggles have been exceptionally fraught, or at any rate, exceptionally conspicuous in recent decades, South Africa. An upper middle income country in World Bank terms, South Africa combines rich world living standards with conditions that involve serious development deficits. It is consistently ranked as one of the world's most unequal societies. This is widely recognized within the country. For example, a recent official report on national inequality trends takes as its starting point the extremely high and remarkably persistent character of South African inequality. Despite many efforts by government to reduce inequality since our democratic transition in 1994, the report comments, progress has been limited. Public infrastructure is a domain in which inequality remains particularly stark, and in no dimension more so perhaps than in sanitation. The question of how South Africa's history of racial segregation bears on its current sanitary realities will be central to my inquiry in this lecture. For now, it suffices to note that access to waterborne sanitation was historically a benefit created for and enjoyed by the country's white minority and a relatively limited number of others. Infrastructural investment prioritized the predominantly white neighborhoods of cities and towns. For Black South Africans forced out of cities into rural areas and townships, going to the toilet meant the so-called bucket system or open defecation. The post-apartheid period has seen considerable improvements in the sphere of sanitation. As I just mentioned, however, this period has also seen the perpetuation of large disparities in the distribution of sanitation services. Thus, one learns from the latest nationwide statistical survey that 63% of South African households have access to a flush toilet, public or private. Unfortunately, my slides are slightly obscured by Sandesh and myself, so I can't see the final column there, but I think the 63% I calculated by adding together the two top figures relating to the flush toilet connected to public sewage and the flush toilet connected to a septic or conservancy tank. Members of the remaining households use, as you see there, a range of facilities, of which pit latrines with or without ventilation pipes are the most common, or they have no facility at all. In just over 1% of cases, corresponding to 186,000 households, the bucket system continues to be used. The statistical survey further shows that pit latrines, along with chemical toilets, the bucket system, and open defecation, are overwhelmingly a feature of informal dwellings and of Black households. Almost no white households do not have access to a flush toilet. By informal dwellings is meant here shacks or shanties situated in backyards and in informal or squatter settlements, that is to say, settlements to which the inhabitants have no formal legal claim. To refer one final time to the statistical survey, 12% of South African households occupy informal dwellings, and dwellings of that sort are most commonly found on the periphery of the country's largest two cities, Cape Town, where 19.6% of households live in informal dwellings, and Johannesburg, where 19.1% live in informal dwellings. My discussion this evening will take us to both those cities and their peri-urban informal settlements and apartheid-built townships. It will also take us to a third city, Durban, where municipal planners have gained a reputation in recent years for innovation in the delivery of sanitation services. We will follow efforts by poor communities to secure better sanitation through resort to a variety of tactics, including, but not limited to, legal proceedings against public authorities. Such litigation relies on a raft of legislative enactments and standard-setting policies that have been adopted in the years since 1994 relating to water and sanitation services. The litigation also relies on the South African Constitution of 1996, with its celebrated protection of socio-economic rights and its celebrated provisions concerning human dignity. Under Section 27(1) of the Constitution, everyone has the right to have access to sufficient water. Under Section 26(1), everyone has the right to have access to adequate housing. Under Section 1, equality is among the foundational values of the state. And Section 9(2) specifies that equality includes the full and equal enjoyment of these and other rights. Human dignity is also among the foundational values proclaimed in Section 1. Under Section 7(1), the Constitution's Bill of Rights is said to affirm that value. Section 10 then declares that everyone has inherent dignity and the right to have their dignity respected and protected. Together, these provisions have been understood to entail that dignity is both a foundational value to be promoted and a justiciable and enforceable right. In an early judgment of the South African Constitutional Court, Justice O'Regan made the often quoted observation that the recognition and protection of dignity is the touchstone of the country's new political order. Indeed, dignity has a prominent place in South Africa's transitional justice discourse. It was, for example, part of the mandate of the Truth and Reconciliation Commission to restore, as it said, the human and civil dignity of the victims of gross violations of human rights under apartheid by, in the founding documents' words, granting them an opportunity to relate their own accounts of what had happened to them. Whether, how, and to what extent dignity was or could be restored through this process is, of course, a matter of ongoing contention. Nadine Gordimer seems to have anticipated something of the problem in her novel July's People. Published in 1981, the novel is set in a future South Africa. It imagines a violent end to apartheid. As civil war rages, a white couple, Bamford and Maureen Smales, and their children flee Johannesburg with their black servant, whom they call July, traveling with him to his village and living there under his protection. The couple are liberal people who believe they have treated their servant with dignity. One aspect of this has to do with sanitation. We learn that in the Smales family house, July had his own bathroom with, quoting from the novel, a bath, white china lavatory, everything. Over the course of the novel, a series of confrontations occur between Maureen and July that eventually compel Maureen to realize that from July's perspective, to be dignified for her meant nothing. His measure as a man was taken elsewhere. Pertinently for this lecture, sanitation could not be dignity in conditions of servitude. But if the man, whose real name in the novel is Mwawate, had access to a flush toilet only for so long as he remained a servant, what view will he take once he becomes a constitutionally equal citizen? I spoke a moment ago of efforts to secure better sanitation, but in beginning now to go into this aspect of recent South African history a little more deeply, I should clarify that sometimes the issue has been to preserve existing levels of access to improved sanitation. Here I want to refer to the case brought to court in 2006 of Mazibuko and others versus the city of Johannesburg and others. The applicants in this case were 5 residents of Piri, a township in Soweto, established in the early years of apartheid and still with an almost entirely Black population. And their claim related to certain changes that had been implemented affecting the supply of water to their homes. The respondents were the city of Johannesburg, within the local governance of which Soweto was incorporated in 2002, and 2 other entities with responsibility for water supply. Until 2004, the applicants, in common with others living in Piri and in Soweto more generally, had received an unlimited supply of water for which they were charged a flat rate based on deemed consumption. It seems that credit control was not strict, householders were routinely in arrears with their payments, and the flat rate was in any event too low to recover the cost of actual consumption across the area. In keeping with global trends, the water authorities decided to move to a more commercially functional system. Residents of Piri and other parts of Soweto were given the option of having their in-house water disconnected and getting water from external standpipes or whatever other external source they could find, or having prepayment meters installed. Some residents initially took the first option, but the hardships involved led almost all eventually to accept the installation of prepayment meters. Under the traditional metering system used in wealthier and predominantly white parts of Johannesburg, water was provided on credit, and households were given notice and an opportunity to make representations before supply was cut off. In contrast, the prepayment metering system delivered a fixed amount of so-called free basic water, and when that ran out, the water supply was automatically cut off until the next month, unless additional water credits were purchased. The free basic water allowance was 6,000 litres per household per month, reckoned as 25 litres per person per day in a household of 8. So that's number 1 in my sheet on your screen. I'll come back to the question of household sizes a bit later in this lecture. Like many of those affected, the applicants in this case could not survive on that amount, but did not have the money to purchase any or sufficient additional water credits, which were charged according to a relatively steep rising tariff. As a result, their water stopped before the end of each month, and they then had to wait days, or quite commonly weeks, for reconnection. In these circumstances, the applicants challenged the constitutionality and regulatory legality of both the system of prepayment water meters and the amount of the free basic water allowance. They sought a declaration that they and others in Piri on whose behalf they brought this class action were entitled to 50 litres of water per person per day, an amount that corresponded to 12,000 litres per household per month, when calculated on the same basis as the 6,000 litre allowance that had been set, in other words, number 2 on your screen. At first instance, Justice Tsoka upheld the applicant's challenge and made the declaration they sought. He ruled that the system of prepayment meters contravened inter alia the equality guarantee in the Constitution, and he considered that 50 litres of water per person per day was indeed the appropriate amount to enable a dignified existence. On appeal by the respondents, the Supreme Court of Appeal reduced that amount to 42 litres per person per day, or 10,000 litres per household per month. That is number 3 on your screen. The Supreme Court also gave the water authorities 2 years to attempt to legalise the use of prepayment meters. The applicants then took their case to the Constitutional Court, the highest court in South Africa, which dismissed their appeal and set aside any increase in their water entitlement beyond the original 6,000 litres per household per month. I quoted earlier Section 27(1) of the South African Constitution on the right to sufficient water. Along similar lines to international human rights law, Section 27(2), that is to say subsection 2 of the same section, provides that it is the correlative obligation of the state to take reasonable measures within its available resources to achieve the progressive realization of that right. Writing for the Constitutional Court, Justice O'Regan summarized the implications of this in the following terms. If the state takes no steps to realize the right, the courts will require the government to take steps. If the government's adopted measures are unreasonable, the court will similarly require that they be reviewed so as to meet the required constitutional standard of reasonableness. As she glossed it, and now again quoting, a reasonableness challenge requires the government to explain the choices it has made. For the Constitutional Court, the government had done this satisfactorily. The prepayment metering system was not unreasonable, and so too the Water Authority's decision regarding the free basic water allowance was not unreasonable. Regarding the latter, the free basic water allowance, Justice O'Regan noted that the expert evidence provided, quoting now from her, numerous different answers to the question of what constitutes sufficient water, and courts are ill-placed to make these assessments for both institutional and democratic reasons, end of quote. Let us pause here to take in the conflicting expert evidence to which Justice O'Regan refers. The experts on which each side relied more or less agreed on the amount of water that is required per person per day for drinking, bathing, cleaning, and meal preparation. Where they differed, and we now begin to approach the issue with which this lecture is concerned, was on the amount needed for sanitation. Piri is connected to main sewerage, and the applicants were among those South Africans who had access to a flush toilet. According to the expert evidence adduced on their behalf, the basic requirement for waterborne sanitation starts at 20 litres per person per day, but where houses are connected to inefficient sewerage systems, as is commonly the case in South African townships, that rises to more than 75 litres. According to the evidence adduced on behalf of the respondents, the appropriate figure is instead 15 litres, calculated as 1.5 toilet flushes per person per day. Explaining this, the Water Authority's expert, who was also their civil engineering consultant, said that, and now quoting, "It is in fact only essential to flush after defecation, which takes place once for a healthy adult. Flushing a toilet after urination has no health benefit and is probably done for aesthetic reasons more than anything else." It followed that an allowance of 1.5 flushes was, he said, entirely reasonable. That passage appears in a section of the expert's report headed "Quantifying the amount of water needed for health and human dignity." How many times is it reasonable, necessary, and dignified to flush the toilet each day? For the judge at first instance, to expect the, and now quoting, "to expect the applicants to limit the number of toilet flushes they make is to deny them the right to lead a dignified lifestyle." End of quote. In reaching this conclusion, he pointed to the country's history of inequality and indignity, which he said was still too fresh in people's minds to ignore. And just as he pointed to history, so too Justice Tsoka highlighted the significance of geography. I mentioned his ruling that the prepayment metering system contravened the Constitution's equality guarantee. Specifically, he said that the system discriminates between the residents of the city on the basis of geography, and that the situation was one where, in his words, geography revealed the true basis of discrimination as colour. The Constitutional Court gave relatively short shrift to this aspect of the case, fairly quickly dismissing the allegations of inequality. Justice O'Regan observed for the court that the prepayment metering system was not used in all historically Black areas of the city, and also that the residents of historically white areas were as restricted as those in Piri, in that they were compelled to use conventional credit meters and could not opt to have prepayment water meters installed in their homes. No reference was made to dignity in the Constitutional Court's judgment. Yet if, as Justice O'Regan writes, courts are ill-placed to make assessments about what Antina von Schnitzler has neatly termed metrologies of dignity, from the applicant's perspective, Piri residents had a constitutional right to water and a constitutional right to dignity, and here the Constitutional Court was deciding that 6,000 litres of water per household per month, or 1.5 toilet flushes per person per day, were what those rights entitled them to. Von Schnitzler is an anthropologist interested in legal processes. Excuse me for a second. Interested in legal processes and how they relate to lived experience. In a series of interviews with the applicants in this case after the proceedings were over, she posed the question to Jennifer Makoatsane, the third applicant. So if you were given 50 litres per person per day, that is the amount sought in the legal statement of claim, would that be fine? The answer that came back was It's not for them to tell us. Von Schnitzler understands this to imply that Makoatsane objected not to calculation per se, but rather to who did these calculations and how. Human dignity is declared by philosophers in constitutions and treaties to be inherent and primordial, the fundament upon which a modern state is founded, and Kant teaches that it is elevated above any price. But to this 35-year-old unemployed South African, nothing could be clearer than that dignity was evaluated, measured out, and dispensed in these juridical and administrative procedures. Nothing could be clearer than that, far from being foundational, dignity was an outcome of these determinations by judges, policymakers, officials, managers, and consultants, through which authoritative knowledge regarding it was produced. Yet, in her words, they don't know. In a moment, we will move from Johannesburg to Cape Town, but just before leaving the Mazibuko case, I want to touch on an episode that occurred slightly before the case was heard by the Supreme Court of Appeal. On the 12th of February 2009, a group of women staged a march through downtown Johannesburg in support of the 5 residents' legal challenge. According to a statement by the organizer of the demonstration, women without water and sanitation are as good as dead and have no dignity. There were banners with messages like "Sanitation equals water is dignity for women," and "Stop the war on," "Stop the war on women's bodies." And it is reported that some of the women wore unwashed, blood-soiled or red-stained underwear on top of their clothes. Interviewed by a journalist, one demonstrator said, "We are marching because we are dirty." In the legal proceedings, as von Schnitzler describes, the applicants had been obliged to develop a narrative that focused on the exposed body and its needs, making their case dependent on foregrounding their vulnerability, injury, and shame, testifying to how, for example, the problems caused by the prepayment meters and the 6,000-litre allowance became more acute when residents menstruated, in that, to quote from the record of evidence, "During this time, I would feel very embarrassed should a male person use an unflushed toilet behind me." In this demonstration, by contrast, gender-based indignity was mobilized and performed in a way that re-signified shame. As Karen Zivi also reflects, these demonstrators turned notions of female impropriety against the state. The women refused to be shamed and instead shamed the state for the class structure and associated inequalities of race and gender, of which to them the prepayment metering system was an emblem and material component. Activism of something like this kind has played a much discussed role in disputes with the Cape Town municipal authorities over sanitation arrangements there. Let us turn to that set of issues now, which surfaced at around the same time as the events in Johannesburg I've recounted, as well as in subsequent years. The township of Khayelitsha was established late in the apartheid era on the sandy, low-lying Cape Flats to the southeast of central Cape Town. Growing rapidly, it encompassed by the 2000s a number of informal settlements. In 2004, a project was launched to upgrade some of these settlements, and as part of the project, to provide waterborne sanitation ahead of new housing. Initially, the plan was to build communal toilets, 1 for every 5 households. However, the city accepted the community's contention that this would be unsatisfactory. Under a revised plan, private toilets would be installed, that is to say, 1 for each household, but no structures would be built around them. It would be left to individual residents to construct enclosures for their toilets. The installation of unenclosed toilets began in 2009. By early 2010, most of the toilets had been enclosed by residents, but in the Makaza section of Khayelitsha, 51 toilets remained unenclosed. Photographs of open toilets circulated widely in the media, along with stories of users having to cover themselves with blankets. And there you see one of the open toilets. 76-year-old Makaza resident Ngombencha Beja was among those whose toilet remained unenclosed. And one evening in April 2010, she was knifed while on her way back to her house after visiting a toilet 10 minutes away. As elsewhere in the world, attacks on women and girls are a concomitant of inadequate sanitation in South Africa. A report by the South African Human Rights Commission denounced the unenclosed toilets as a violation of the residents' rights, including, in particular, their right under Section 10 of the Constitution to have their dignity respected and protected. Shortly after the report was published, Ngombencha Beja and 2 others initiated proceedings against the City of Cape Town and other relevant officials and governmental agencies in the Western Cape High Court, which gave judgment to similar effect. Justice Erasmus remarked that it was, quote, disturbing to note from correspondence between the consulting engineers and the municipal managers that the unenclosed toilets were referred to as loos with a view. This terminology is reprehensible, he said, and fails to afford any regard to the dignity of poor people compelled to use these toilets in unfortunate circumstances. Even the self-enclosed toilets, screened with whatever materials residents without money could find, did not satisfactorily protect dignity and privacy in his assessment. Overall, the judge opined that the municipal authorities had, in his words, lost sight of the needs of the poorest of the poor and their human dignity. Upholding the applicant's claims, he held that the respondents had violated the residents' constitutional rights, and he ordered the city to enclose or re-enclose all 1,316 toilets that formed part of the sanitation project. Stephen Robbins comments that prior to this point, now quoting, the shocking sanitation conditions in South African informal settlements seldom made it into the mainstream media or national political discourse. Thanks to the spectacular image of the open toilet, the conditions were created for the framing of sanitation as a matter of broad public interest, and hence a concern for politicians, activists, journalists, citizens, and as we have seen, human rights commissioners and judges. In the domain of the courts, Robbins writes, the open toilet came to stand in for the indignities and injustices of daily life under apartheid, as well as the limits of transformation after apartheid. Linked to this, the open toilet challenged dominant narratives about transitional justice, increasing the visibility of everyday realities of structural poverty that could only be addressed through long-term state interventions at a systemic level. That said, Robbins also comments that Justice Erasmus's language in the Beja case was easily assimilated into an official script that reenacted the commitment of the caring post-revolutionary state, a state which affirmed the dignity and equal worth of all South Africans and had no truck with contemptuous engineers and managers disposed to make light of the sufferings of the poor. Regarding the practical problems of sanitation, it seems to have been a result of the judgment, or at any rate of the larger open toilet scandal of which it was a part, to put an end to the installation of unenclosed flush toilets. Though, as would soon become clear, Cape Town's toilet wars were only just beginning. A further episode erupted in 2013 and related to another scheme of sanitation in Khayelitsha informal settlements, the provision of portable toilets in cubicles. There you see them from the outside, and here you see one from the inside. Presented as a temporary measure, these had been in place in some areas for many years. Portable toilets require chemicals and frequent emptying, but there were problems with the arrangements that had been set up for dealing with that. Unwilling to use toilets that were commonly in an atrocious state, many residents, not perhaps reflected in that image, but there were others I could have chosen. Many residents resorted to the use of makeshift pits, plastic bags, or toilets belonging to relatives or friends some distance away. To draw attention to this situation, a campaign of direct action was initiated that saw the contents of portable toilets deposited in a number of public places. Feces was thrown onto the steps of the provincial parliament, onto the entrance of a governmental building, onto officials passing cars, onto a busy motorway, and the target that apparently garnered the most publicity, onto the main terminal building of Cape Town International Airport. City centre demonstrations were also held, at which demonstrators came with portable toilets and sat on them and waved around cardboard cutouts of toilet seats, as you see in that slide. Beyond the courtroom dramas of the exposed body and its needs, what thus unfolded at this time on Cape Town streets was a parody of abjection, an ironic performance of indignity that, as in the Johannesburg Women's March, re-signified shame and threw it, now literally in the form of excrement hurled from portable toilets back at the state. Nadine Botha has written about the passage of the portable toilet from camping accessory to protest totem. She explains that the first patent for a portable toilet was filed by Thetford Corporation of Ann Arbor, Michigan in 1969. Thetford portable toilets, along with another brand, are those used in Khayelitsha, though apparently there is no mention in the company's publicity material of bulk sales to the city of Cape Town. Botha notes that Thetford portable toilets received glowing reviews on Amazon from recreational vehicle users, truck drivers, campers, boaters, and the like. There you see what I think is probably a more recent model, but you can see quite a few ratings and many stars. As Botha observes, however, occasional use of well-maintained portable toilets by people with access to a conventional toilet in their regular lives is one thing. Daily use of poorly maintained portable toilets over many years by large families whose only other sanitation options are as bad or worse is quite another. Shannon Jackson and Stephen Robbins point to the simple urgency of too many South Africans living too close to their own waste. At the same time, the Khayelitsha portable toilets are elements in a pattern of social exclusion that renders residents of informal settlements themselves a kind of waste. Connecting this with Cape Town's longer history of racial and spatial ordering that from early colonial times conflated the original inhabitants with contaminating waste and expelled them outside the city limits, Jackson and Robbins tell of a potent semiotics of waste and of excrement as a weapon of political reversal. Through the actions of these toilet warriors, the undignified sights and smells of the periphery were being brought to, flung at, released in, and crucially, made belongings of the privileged centre. Why were prepayment water meters installed in Piri? Why were toilets provided in Makaza without walls? Budgetary considerations were clearly important, but I want to mention now another factor highlighted in a statement by a leading Cape Town official of the time. She said, "We have come to the conclusion that the best way to instill a sense of ownership and an ethos of respecting property is for each family to contribute to the construction and maintenance of their own toilet." Residents of Makaza and adjacent informal settlements were being left to build their own enclosures, at least in part, because this encouraged, in her words, self-reliance and initiative. In Reflections on the Toilet Controversies, Brendan Barnes writes of how familiar themes along those lines informed discourse about infrastructural improvement in South Africa. As he tells it, the post-apartheid state has promoted a version, now quoting, a version of active citizenship that acknowledges rights but emphasizes agency, choice, volition, responsibility, and participation. Communities are expected to help build facilities, or at the least, as Barnes explains, to adopt technologies such as prepayment water meters and portable toilets until the state can figure out long-term solutions. Within this discourse, he continues, again quoting, "Poor South Africans have a right to be unhappy about the slow progress of South Africa's development, but they should express their discontent responsibly through voting and other recognized political channels." Barnes describes state-sponsored campaigns that also seek to mold behavior in other ways. In connection with the installation of prepayment water meters, citizens were advised on how to use water responsibly, including how many times to flush the toilet, and were exhorted to regard payment for water as an act of responsible citizenship by means of such slogans as "Your right to services equals your right to pay," and "I've paid for my services, have you?" From this perspective, prepayment water meters, toilets without enclosures, and portable toilets are not just modes of sanitation, deficient modes of sanitation. They are moral pedagogical devices, to use Barnes's phrase, that provide instruction in what it is to be a good citizen. I indicated at the beginning of this lecture that Durban would be part of my story, and I want now to refer to a final set of toilet-related measures, which have carried a similar moral pedagogical message to the racialized poor of that city, but which differ in that they are an outcome of efforts in South Africa and elsewhere to innovate the state's way out of the problem of inadequate sanitation. During the 2000s and 2010s, the Durban water authorities rolled out 2 types of dry toilets for use in rural and peri-urban areas not connected to its sewerage system: ventilated improved pit or VIP toilets and urine diversion or UD toilets. VIP toilets were originally invented in the 1970s by a research laboratory in what was then Rhodesia. These modify the standard form of pit latrine through the addition of a vertical ventilation pipe designed to reduce odors and inhibit the breeding of flies. UD toilets are a much newer and more sophisticated technology involving sealed units, which divert urine into a separate compartment so that feces can dry out more quickly and be more readily disposed of. In keeping with the ethos of responsibilization just mentioned, UD toilets are self-maintained toilets. Once provided with them, householders must dig holes and dispose of the residue of fecal matter at suitable intervals themselves. In August 2010, a workshop was held to discuss the introduction of UD toilets in Durban, and Barbara Penner was among those attending. Penner recalls that, now quoting, "At first glance, the UD toilets appeared to me a relatively straightforward solution to the problem of providing basic sanitation in water-stressed regions such as Durban. After all," as she observes, "the developed world's waterborne model of sanitation, with its reliance on big system infrastructure, needs rethinking. And not only for reasons of cost, water scarcity is only getting worse due to climate change." But the Durban scheme had encountered considerable community resistance. For while, now quoting from Penner, "the UD toilet is unquestionably an improved form of sanitation if compared to a bucket, pit latrine, or portable toilet, it did not look so good to residents when set against the plumbed-in flush toilet. Indeed, the UD's self-maintained technology," again quoting from Penner, "contrasts sharply with that in full service areas, where householders do not maintain pipes beyond their property lines and are able to flush and forget their waste." The key point was that residents needed only, again quoting from Penner, to look at the country's still predominantly white privileged class, whose members are not expected to use UD toilets, for proof that the distribution of sanitation options largely follows existing race and class lines. In the end, Penner proposes that, in her words, a central reason why improvement projects stumble is asymmetrical provision and resource allocation. If the effort to achieve social justice and to conserve resources is to be credible, she writes, the behavior, habits, and expectations of full service users, those with a flush toilet, must be reformed alongside those on the bottom rung, who, let us not forget, consume the least. Some years after Penner's seminar, Noshipo Mkize and colleagues conducted a study of attitudes to UD toilets by their users in Durban. Among Mkize and colleagues' findings was that all of those surveyed aspired to have a flush toilet, which is associated, now quoting from the study, with being a first-class citizen. Peter Redfield and Stephen Robbins have an illuminating take on the gap here between popular and official thinking. In their analysis, there can be discerned in this context two quite distinct conceptions of dignified life, corresponding to two quite distinct techno-political imaginaries. Starting on the official side, there is a humanitarian design imaginary, as they call it. I've been speaking about UD toilets, but in fact, this is one of many attempts in recent decades to develop new forms of dry toilet, especially for low and middle income countries where infrastructure is scant and significant proportions of the population lack adequate sanitation. Underpinning these attempts is the claim that the flush toilet, however originally progressive and still valuable, fails to meet global needs. In 2011, the Bill and Melinda Gates Foundation launched a Reinvent the Toilet Challenge. And since then, a series of reinvented toilet fairs have been held in various parts of the world. If you visit the website of a design consultancy called Bridge Factory, you will see pictures and a description of a toilet that won first prize in another humanitarian industrial design competition relating to sanitation. No prizes, however, for guessing the name of that toilet. The Dignity toilet is, as you see, an attractive lime green and white molded plastic object reminiscent of a piece of modernist furniture, and is said to provide sealed sanitary storage for solid waste for 3 people for approximately 7 days. Parenthetically, you may recall my mentioning that the prepayment meter calculations in Piri were based on a household size of 8. Whether it was appropriate to allocate free basic water per person or per household was a matter of considerable contention in the Mazibuko case. But it's worth noting in the present context that the judge at first instance made a finding of fact that the average household size in Piri was actually around 16. These are often multi-family households with a main house and additional informal dwellings on the same site. At least at the time that case was heard, when so many families had been ravaged by AIDS, they were also households in which children had been left without parents and were being brought up by grandmothers and aunts. Anyway, back to the Dignity toilet. After the 5 or whatever day period, the toilet is removed from its dock and taken to a predetermined communal area where its contents are manually augured, which I understand means bored down into the soil for decomposition. Bridge Factory's promotional material bills the Dignity toilet as a product that inspires pride in its owners, not a disposable commodity. It's this way of approaching things that constitutes what Redfield and Robbins term the humanitarian design imaginary. In their words, for the designers, dignity is a question of technology and the aesthetics of individual experience. End of quote. Humanitarian designers and their utilities sector customers conjure dignified living through innovative sanitation solutions that combine clever engineering with careful attention to design, and one might add marketing. To this, Redfield and Robbins counterpose another different imaginary, according to which dignity is instead a political issue and problem of social justice. This social justice imaginary is reflected in the events I've mostly been narrating in this lecture, and in the findings of Mkhize and co-authors about attitudes to UD toilets in Durban. Central to its way of approaching things is a belief that the question of dignified living cannot be addressed without reference to history and its legacies in the present. Whereas the humanitarian design imaginary largely floats free of any specific legacy of the past, except the invention of the water closet itself, the social justice imaginary invokes an intimate history of racial and gender injustice with notable geographical dimensions. To be sure, the intimacy of the toilet and what goes on there also has a history and a geography, not to mention, for some theorists, a psychology. The humanitarian design imaginary and the social justice imaginary coexist in a world shaped by those developments. Where the social justice imaginary departs is in holding that dignity in the sphere of sanitation is not just a technological challenge, however much it may also be that, and still less is it just a promotional and branding matter. It's a problem of structural inequality. Social Justice Coalition is a Cape Town-based NGO active in the area of sanitation. On the 21st of March 2010, the organization staged a protest, which they called the Long Walk to Human Dignity. The protest involved members forming a long snaking queue for a public toilet in the wealthy Cape Town district of Sea Point. One reads on the organization's website that in this area, as in other affluent suburbs, public toilets are cleaned and maintained regularly by a dedicated caretaker. They are well lit and they're monitored frequently by security personnel. This is in stark contrast, we read, to the public toilets in Khayelitsha, which are unsafe, never cleaned or maintained, nor provided with the luxuries of toilet paper or a simple toilet seat. The Long Walk to Human Dignity alludes, of course, to Nelson Mandela's autobiography, Long Walk to Freedom. In a famous passage of that book, Mandela writes of how prison and the authorities conspired to rob him of his dignity, and of how that paradoxically assured that he would survive inasmuch as Any man or institution that tries to rob me of my dignity will lose, because I will not part with it at any price or under any pressure. It's a noble and appealing sentiment, but the long walk to human dignity refocuses on indignity and its persistence after and notwithstanding liberation. At the level of ordinary life, the long walk to human dignity reminds us of the indignity of being deprived of access to a clean and safe toilet, along with the indignity of being deprived with a toilet that preserves your status as a second-class citizen, the indignity of being precluded when you have a flush toilet from using the flush with the frequency you deem necessary, and the indignity of knowing that such is the social systemic order under which you live, that privileged South Africans, spared these experiences, rob you of your dignity each and every day. In the same transitional decade as Long Walk to Freedom came out, J.M. Coetzee's novel Disgrace appeared. It tells the story of David Lurie, excuse me for 1 second, of David Lurie, a lecturer in English literature at a university in Cape Town, and of his adult daughter Lucy, who lives on a farm in the nearby Eastern Cape. After many vicissitudes, David and Lucy have a discussion about Lucy's future. Something terrible has happened to her, and she has decided that she needs to make a new start, and that in doing so, there is a particular course of action she must follow, which involves humiliation and self-denial, and seems completely at odds with her interests and welfare. When David expresses dismay, this is how Lucy responds. Yes, I agree it's humiliating, but perhaps that's a good point to start from again. Perhaps that is what I must learn to accept, to start at ground level with nothing, no cards, no weapons, no property, no rights, no dignity. Disgrace is often read as an allegory of post-apartheid South Africa and a critique of the truth and reconciliation process that was ongoing at the time it was written. Lucy is a white South African, and here Coetzee is having her express the belief that dignity, at least as she has known and enjoyed it, must be renounced as part of the same political and social order that brought South Africa cards, weapons, property, and rights. We might understand that catalogue to imply the intersection of white supremacy symbolized by the identity cards of the apartheid era, violent subjugation, weapons, economic exploitation, property, and legally protected privilege rights. A fantastically complex novel, Disgrace does not, I think, purport to resolve the unsettling issues it raises. Regarding dignity, one thing it does clearly signal, however, is that confined to the realm of abstract metaphysics, the issues are not. We have seen in this lecture how dignity and indignity have played a part in disputes over inequality and sanitation in post-apartheid South Africa. Starting with Gaudimer's July, of whom Maureen finally learns that to be dignified for her meant nothing, we have seen how dignity has been variously quantified, allocated, parodied, imagined, owned, and renounced. I want to end now with reference to an event in the larger struggle within which these disputes find their place. It is well known that the Rhodes Must Fall campaign emerged in early 2016 in connection with a long-standing demand to have a bronze statue of the mining magnate and leading colonial governor and ideologue Cecil Rhodes removed from the campus of the University of Cape Town. Erected in 1934, the statue stood on a high plinth at the foot of the steps leading up to the university's convocation hall, where ceremonial occasions are held. And it depicted Rhodes seated and with a contemplative air. The university authorities eventually hired a crane to take it away on the 9th of April, 2015. For its part, Rhodes Must Fall went on to catalyse and energise a project of decolonial activism in higher education, cultural heritage and everything else, both in South Africa and around the world. What may be less well known is how this great movement began. On the 12th of March 2015, one Chumani Maxwele, a 30-year-old fourth-year political science student, stood beneath the statue of Rhodes and with all his force flung up at it the contents of a portable toilet, which he had carried to the campus in a minibus from his home in Khayelitsha. Addressing the assembled crowd, he is reported to have declared, "There is no Black collective history here. Where are our heroes and ancestors?" It was a powerful point about practices of memorialization and how they are marked by the lingering stench of empire. But in a later interview, Maxwele explained that there was also something else he wanted to communicate. He said that he threw feces at the statue to highlight our shame. "We want white people to know how we live," he told the interviewer. "We live in poo. I am from a very poor family. We are using portaloos, portable toilets. In order for me to bring evidence, I have to give Cecil John Rhodes a poo shower, and whites will have to see it." Thank you very much.
Professor Marks, on behalf of the Louter Park Centre and the audience over the last 3 days, thank you so much for a really terrific, thought-provoking, fabulous set of lectures. Thank you. And we look forward to our discussion tomorrow, which will begin at 1 p.m. See you all then. Goodbye.